Okay, I call the case of Dennis Valuch, Valuch. And sir, are you still on 13111 West Cameroon in Butler?
13111 West Cameron Avenue, yes.
Okay. And versus International Autos Group, and is that the proper name for the respondent?
Yes, Your Honor.
Okay, and should a copy be sent to the South 108th Street address or to Kathy Mallow, on the Moreland in Waukesha?
Kathy Mallow is on the South 108th Street address, Your Honor. That would be the appropriate mailing address and appropriate person to put it attention to.
Okay, so she is not at the Waukesha address that Mallow is at the South 108th?
Correct.
Okay. Okay, this is ERD case number CR20 1900490, EOC case number 26G2019005444C. I'm Administrator Law Judge James A. Schacht, SCHA-CHT. Appearances for the parties, please.
This is Rebecca Salawda, Salawdeh, appearing on behalf and with the complainant, Dennis Valuch.
Attorney Joshua Brady, Brady, appearing on behalf of the respondent, International Autos Group. Good morning.
Morning. This is a it's always interesting in dealing with the matters to finding where everything is on your tabletop is one of the major things regarding the computer. This is a hearing on the merits to determine whether International Autos Group violated the Wisconsin Fair Employment Act by discriminating against Mr. Valuch in terms and conditions of employment and terminating his employment because of age and disability. We are dealing with that the situation regarding the issues for the case as discussed is whether or not the discharge from the service manager position on June 8th, 2018 was because of age or disability, whether the discharge from the workshop dispatcher position on June 29th, 2018 was because of disability, and did the complainant fail to mitigate his damages by declining the service advisor position when it was offered. That in dealing with, I'm sorry? Somebody was saying something or just hearing an echo? My understanding is that at this point, as far as that there's a discovery motion granted regarding some issues for the case, but my understanding is that at this point anyway, in dealing with the McDonnell Douglas articulation of legitimate non-discriminatory reasons, that the respondent at this point is saying that the reason for the discharge from the service manager's position regarding to flat production and from the workshop dispatcher position regarding that it was not as productive as hoped. Now, how in the circumstances that the issue of production can be dealt with in the connection regarding the discovery issues will be yet to be determined. Of what that means, and also just simply to note that I'm not sure in regarding in this relation as to what extent, particularly on the second one, that we aren't dealing with a prima facie case there, or whether or not that we do have a proffered legitimate non-discriminatory reason. those are issues for briefing or other discussion later on. Also note in the matter that there was, in connection with the motion, that I have indicated that the Ms. Lotta has 7 days to offer a attorney's fees position and to any argument as to why they should be granted in the circumstances, and the respondent has 7 days to respond, which includes dealing with any argument as to why attorney's fees should not be granted in connection with that motion. Is there any issues regarding what I just went over, or at this point?
No.
I'm not hearing any.
I was going to defer to the complainant first, Your Honor. As it relates to the respondent, the second position was eliminated as it works, as it pertains to the workshop dispatch position. So there is an added layer as it relates to the elimination of that position, Your Honor.
I don't understand what you just said.
Nope. It indicated the production from the workshop dispatch. That was the position that was started in June of 18 and ended in June of 18. That position itself was eliminated within the company. So that's an added component to the respondent's case to add at this
Okay,
juncture.
articulation that basically is saying that at some point, and this is dealing with a thing regarding the decision, that there was a decision by the respondent to eliminate all workshop dispatcher positions, you're saying?
Correct.
And I would understand that when and whether or not this was known or contemplated prior to June 8th, 2018, obviously would be relevant. So also in just dealing with in the manner, and I'm not sure in the circumstances this suggests, if it's company-wide, that may be some other people involved, and also in the matter that the whether or not the discovery of the situation impacts on Ms. Lotta's ability to respond to a per-offered reason in the circumstances of who is involved is also something that that I'll have to deal with subsequently, because that anyway, I'm that the situation regarding the just to note regarding the situation that allows us to go forward here today, I have two levels of dealing with things regarding the discovery matters. One, the extent to which it impacts on the hearing, and to a great extent, I just simply would note that I want to make sure that to a great extent for the hearing, I will try to if the concern regarding making an adequate record for the respondent for the so that the commission can see or knows what's eliminated in case that they want to dispute my decisions, which sadly enough that they sometimes do. I can't imagine why they would ever question my decisions, but that's their right on appeal. So there's issues regarding the scope of dealing with the hearing, and then there are another set of issues regarding the for briefing, and I just will check in the circumstances that I assume that one or both of you wants to brief this matter. Is that correct?
Yes.
Yes.
Okay, and since there are a variety of different things, so that is 3015, for 30 days for initial briefing and 15 days for replies adequate? And I mean, the thing is, the matter if in the course of the two of you saying that, okay, well, you need 35 or something like that, or adjust in the matter, that you can stipulate to if for various different matters where it falls. But basically, this seems to be a case in which I need both initial briefs and responses from both of you, since there are a variety of different things which, you know, which of the extent to which your positions on different things are, each of you needs to be able to have a chance to respond to it. Is that, you know, to clarify, because there's a variety of positions on the matter that I'm not clear on. Is something approaching 30 days, 30-15 for a response appropriate and regarding briefing?
Yes, that would work.
I think we need a little, or at least I need a little more time at the beginning. So I think 40-15, just pursuant to my September schedule in those 2 weeks.
That's fine. And I guess,
Unfortunately, then that runs into my October schedule. That's the problem.
okay, well then, I mean, the thing is in the matter is that you need to have enough time. And so why don't in the matter that you two, you know, and go through the matter of what you need and give me a thing so that both of you have time to do it the way you want to. I mean, I'm not going to, that is not a place where it makes any sense to basically say, well, you know, even though you could do it better if you had another week, I'm not going to give you a week. I mean, that's just nuts. So,
I'm sure we can work something out.
yeah, okay. So, you will be dealing with the timing on that, and I also highly encourage you to, if it sounds as though the hearing that you're talking about, if it sounds like the one that I was at, I would appreciate it. There's many briefs that I wonder if we were at the same hearing. I encourage you to actually deal with the matters that is not more persuasive to try to convince me of an alternate reality. You know, so if you're going to spend the time to brief it, you might as well brief the hearing that I saw too. You know, anyway, I just would encourage something that is helpful to me rather than something that isn't. Okay, so is there, and so in the matter that I just saying in the matter that we sort of have two stages, and I just simply would note at the beginning, since I don't know what's the commission, you know, how the commission would deal with this kind of discovery order, I'm more likely to, you know, I want to have a full record here, so at least that the commission knows what has been excluded or whatever, that we have a, I want to make sure in the conduct of the hearing that I don't set up something for a likely, or that the commission would send it back for us to do something bad to it. I mean, I just recognize so that the certain kinds of things may be received to make sure that I have an adequate record when I don't think that it is. I think it's contrary to the motion, to my decision on the motion to consider it for decision. You understand what I'm saying?
Not entirely, because if things are, if something will be considered, then I would need to be able to prepare testimony to address it. But if it's my understanding based on the motion that it's not going to be there, then
I didn't articulate. There's a variety of things, like certainly in the matter regarding exhibits, that it's easy with exclude, that it's clear that when I've excluded an exhibit as to what it is that I'm excluding. The question is in dealing with testimony as to what constitutes an offer of proof, or how do I deal with what I'm excluding, and so I have a record of it. I will, rule at the time dealing with a matter as to what I'm excluding, but then there's a question of what do I need to do to have a record of what's being excluded that's adequate for the commission, and so they don't have to send it back for the clarification. As I said, for exhibits, it's easy, because they can see what the exhibit is. For testimony, it may be more complicated. But the thing is, in the matter at least, that the respondent is not offering any other witnesses other than the 3 that are part of the matter, so we don't have to deal with is that correct? The only witnesses being offered by the respondent are the 3 that have been discussed, correct?
Correct. It would be the 3 that were authorized to testify.
Right, so we don't have to deal with another witness, and we'll see regarding the testimony. Sometimes what I'm saying, normally, the thing is in the matter is that normally in my offer of proof, it is not in a witness testifying about something mode, because I don't think that's clear. What constitutes an adequate offer of proof for something that when I've excluded something, I'm not sure. So I'll have to address that issue, but it'll be in the mode of an offer of proof, not a received testimony and dealing with argue it later, because you have to know what's in for the hearing. So I hope that that's stated better than my initial attempt to describe. It's the question of what evidentially is an adequate offer of proof that I am not sure in the situation, not that I won't make a ruling that you'll be clear about during the hearing. Is that helpful?
Yeah, I think so.
Okay, so, all right, and dealing with also that given the cooperation regarding the exhibits, that this is the current state of them as I understand it. Regarding the complaints exhibit 1, the 2016 earnings summary has been received. Complaints exhibit 2, 2017 earnings summary, that's been received. Complaints exhibits 3 and 4 and 5 have been withdrawn. Complaints exhibit number 6, the 2018 W2 earnings summary regarding Hall imports has been received. Complaints exhibit 7, the 2018 W2 earnings summary regarding international autos has been received. Marked as complaints exhibit 18, the 2019 W2 earnings summary Hall imports has been received. Complaints exhibit number 9, the 2019 W2 earnings summary from Five Corners Dodge has been received. Complaints exhibit number 10, the 2019 W2 earnings summary Fields has been received. Complaints exhibit number 11, the 2020 W2 earnings summary has been received. And then the complaints exhibit number 12, an email dated March 29, 2019 with attachments has been marked. Complaints exhibit number 13, respondent's initial discovery response has been marked. Response exhibit number 14, respondent's first supplementary discovery response has been marked. And complaints exhibit number 15, the respondent's second supplementary response has been marked. The last 4 exhibits, the complainant is reserving to decide how the case goes as to whether those are offered. Is that a accurate issue going over as to what the status is regarding the complainant's exhibits?
Yes, the 3 were withdrawn because they're duplicate of 2 that respondent had.
Okay, and then we have regarding the respondents, we have complaints exhibit respondents 1, the associate handbook has been marked and received. Response exhibit number 2, the compensatory compensation plan effective January 2014 has been marked as and received. Response exhibit number 3, the gross profit chart has been marked. Response exhibit number 4 regarding the employee warning notice dated 1/6/16 has been marked and not received. Both of those. Not that I haven't made any ruling on them. Marked as complaints exhibit number 5 is a workers' comp claim notice, May 24th, 2016, with attachment that has been marked and received. Marked as response exhibit number 6, customer comments has been marked as response exhibit number, and not ruled on. Respondents exhibit number 7, emails dated November 16th through 17th of 2016 has just been marked. Response exhibit number 8, the earnings record, that has just been marked. Response exhibit number 9, the commission calculations, that has just been marked. Respondents exhibit number 10, the hours worked reports, that's just been marked. Response exhibit number 11, the service advisor recap reports, has just been marked. The marked as response exhibit number 12, the Secura, SECURA documents, that has been marked and received. Marked as response exhibit number 13, letter dated June 12, 2018 with attachment, that's been marked and received. Marked as response exhibit number 14 is a letter dated June 27th, 2018, that has been marked and received. Marked as response exhibit number 15, gross profit statements, and that has just been marked. Marked as response exhibit number 16, the complaint, that has just been marked. And marked as response exhibit number 17 is the response to the complaint, and that has also just been marked. And for the respondent, does that accurately describe the condition of the where the respondent's exhibits are currently?
Yes, with the reservation that respondents exhibit 16 and respondents exhibit 17 are for rebuttal purposes only.
Well, I mean, I haven't that, I was just dealing with what was agreed to. And, before you rest, I will ask you regarding, that make sure that something has been done, withdrawn or offered or something on all your exhibits. Okay, so is there anything else that we need to attend to prior to commencing with Mr. Valuch's testimony?
No.
I believe there's a matter of one of the respondents' witnesses that at least preliminary we should, it's regarding Tony Pristula. He did return to work on Monday. He did indicate that he would be available tomorrow to testify. I note that the complainant had indicated a reluctance to allow his testimony as there was no pre-deposition to that. At this point in time, the respondent's position is that we will get in the content of Mr. Pristula's testimony through other means. And so it's potential that we will not need his testimony at all. But I don't expect that we will get to that at least by the end of the day today. So I just wanted to provide an update of his health and his availability.
First of all, I'm glad that his health has improved in dealing with the matter. Then that's, and I'm glad to hear that. My understanding is that at this point that I have no decision as to whether or not to allow his testimony without a previous deposition, correct? You have not decided as to whether or not you want to offer it, correct?
That is correct, Your Honor.
Okay, so since I don't have a decision to make on that, I won't make one. So that's in the matter, and that there is no decision on the part of, so I thank you for the update, and particularly that it's good news that he is doing better, and that we and just to check for your consideration, Ms. Salata, does your position continue to be that you needed to you needed to have a chance to depose him prior to testimony for him to be allowed to testify?
Yes.
Okay, so that's just for your information. As far as I'm not making a decision on it, but it's just that you have that decision. You have. This is the 1:30 and dealing with this is the continuation of the hearing, which we're now dealing with as a discovery and related motion. And just to check, Ms. Lada, that did you receive the amended answer?
Yes, I have not had a chance to review it, but I have received it.
Would you?
Would I what, review it?
Yes,
Okay,
because that's where we're going to start.
okay. Let me also forward it to my client.
I noticed that one of the things to lay out, one of the problems in the situation is that when I asked Mr. Brady for a response to dealing with the claim that my order was not complied with, that the response is completely having to deal with the nature of the order and doesn't respond to what I asked at all. So part of the reason for the issue regarding the consulted and all that stuff was dealt with when I'd issued the order. So it was a non-responsive, I considered it a non-responsive response to the matter. Let me just.
You considered my brief in opposition to the motion to compel as a non-response?
Not to the motion to compel, to the to after I had issued the order, and it was addition to there is not a requirement to a when there's an order for you to comply, there is nothing for the complainant to consult with you about. The question is whether or not you complied with my order or not. That's the question that was being dealt with in the last, I asked before that I granted the motion. I asked for a response to the issues involved regarding whether or not you had complied with my order to compel, not to dispute the order to compel. So it is the second one, which was non-responsive. I had already dealt with issuing the order.
Which second response is the court referring to that was non-responsive? Because the order to provide documents by July 21 was supplemented in document were provided.
It's your response on July 30th. That doesn't respond to the issues before me. I had already granted the motion to compel, so it was dealing with, your response was all about whether or not that she had communicated or whether it was an appropriate motion. The motion had already been granted. So you were just still dealing with whether the motion should be granted. It had already been granted when you responded to the motion on July 30th.
So the court is ignoring the requirement to confer?
No, I dealt with the issue before I granted ordered you to comply with discovery.
In what
I had dealt with
way was that duty complied with?
Anyway, I dealt with it at that point, and there was part of the issue in the matter that my understanding of the situation is that I gave you let me just
You provided deadlines for depositions, deadlines for supplemental disclosures, both of which were complied with. You found that there's no.
In dealing with my understanding is that prior to my July 6th granting of the motion, that you hadn't responded as I instructed you to.
Hadn't responded in what format? On
Between, and I'm not going to, I mean, the thing is, between the motion to compel and my granting the motion, I gave you time to respond to the motion, which in my understanding is you did not. Yeah, I said that I consider discovery closed for Mr. Brady and that he waived his opportunity to respond or dispute Ms. Slaughter's motion by not replying to it or my email.
right, that's when the court disregarded my motion to compel. It decided that
But
the
no,
respondent.
that was late.
that the
It was dealing with late and dealing within the situation. So anyway, you didn't respond when I told you to on the issues that I told you to, in either time. So then I view that you waived the issue by not responding like I told you to. So anyway, that's the great extent to why we are there, because I repeated not responding to what you were instructed to.
And this is
Okay,
the court's,
so-
this is the court's order on July 6th.
Yes.
I hereby order Mr. Brady to answer by July 14th, complete all written discovery and provide all requested documents by July 21st, and to produce all depositions by July 28th. All of which were done.
Well, whether they were done, you didn't, when I gave you an opportunity to talk about whether they were done or not, you didn't talk about that. You talked about something else. So dealing with that, so that has been a consistent problem, that in the situation, I gave you an opportunity to do that, and you were talking about what you could have responded to prior to the July 7th motion, but you didn't respond prior to my July 7th decision on the matter. And so, you need to do it at the time that you're instructed to.
Except I did
So-
respond. I did indicate discovery is forthcoming and then did provide the discoveries.
As far as the record, I could see that there was no, as far as what I asked for a response to, I didn't get a response. You made a motion to compel, which was late, and dealing with, and that wasn't responsive dealing with either. You didn't, and I'm not going to go over these things further. I instructed you to file an answer, which you didn't do when I instructed you to.
Whoa, whoa, whoa. How did I not?
That
file
was
an
after.
answer? When did
You
I?
didn't file it. You didn't
When?
file it before. You filed your answer on July 30th, not prior to July 14th, like I instructed you to do.
That's false. That's blatantly false, Judge. And I need that corrected. That was filed on July 13th. The attorney for the complainant has consented and admitted that she received on that day, and it was provided to you. It was provided to you 3 times before July 30th. So I can't have that be part of this record.
Well, let me check and dealing with the situation as to where I will.
I faxed it and emailed it on the 30th and raised concerns that you weren't receiving my email because you'd indicated you did not receive it.
Well, I will go in dealing with in my situation, look as far as